Good day, liberators and fellow citizens. This morning I'm very cheerful because I'm excited to uh, to share some very interesting and possibly very good news with all of you. Yes, as Liberty Fighters Network, as promised last week, we did lodge our urgent application against the Minister of Health on Friday, the 6th of May, to challenge his so called new amendments to the regulations relating to the surveillance and control of notifiable medical conditions. As you can recall, that way back in on the 1st of April this year, we have also wrote a letter to the Minister of Health, Dr. Phaahla, to say that we just remind him of the fact that, firstly, his predecessor, Dr. Mkhize, way back in October 2020, attempted to make amendments to the very regulations as well, and but those amendments or those draft or that draft at that point never seen the light of day, because at that stage we also put Minister Mkhize under pressure with a letter that we wrote to him then, to say that you cannot implement those regulations because of the fact that the very regulations, the Disaster Management Act regulations that were in force at that point, were challenged, or there's a court order saying that they are invalid based on our 2nd of June 2020 court order, and that the draft at that stage was essentially the same as the Disaster Management Act regulations, and we then said that you would be acting actually illegally if you would continue with those with the implementation. So what subsequently happened was that on the 1st of April we did send a letter, as I've said, and we've warned him that you cannot implement these regulations because of the fact that there should be a 3-month consultative period. And let me just show you what the Health Act, says in relation to that very point. So the Health Act, Section 94A, says that the minister must publish all regulations proposed to be made under this act in the Gazette for comment at least 3 months before the date contemplated for their commencement. And then, if the minister alters the draft regulations as a result of any comment, he or she need not publish those alterations before making the regulations. And a very important point, 4C, the minister may, if circumstances necessitate the immediate publication of a regulation, publish that regulation without the consultation contemplated in paragraph A. So this effectively means that with these regulations that the minister published on the 4th, very near midnight, just before the other regulations, the disaster management action regulations, were supposed to lapse, on short notice, just before midnight, these regulations or this amendment was published. But the problem was that, notwithstanding the letter that Liberty Fighters Network wrote to him to say that you cannot do this, and we've even reminded him again on the 11th of April in a follow-up letter that you may not do it. He did do it. So now we are sitting in the situation that, let me just show you what our court application says. This is our court application that was issued on the 6th under 2022/24917. This is an urgent application that is supposed to be heard on the Tuesday, the 24th of May at 10 o'clock. Why are we giving him so much time? Because this is a review application, an urgent review application, meaning that, and this is what our application is making us different than all others pursued before, is that a review application is a process whereby the rules of the uniform rules of court make provision that you are obliged as the respondent to provide all evidence and the full record of the decision which has led to the promulgation of those regulations. So, to give the minister enough time to get his full record in order, which he was supposed to have by the time he made the decision to implement and promulgate these new amendments. And so it should not be a difficult thing for him to do. So he must just get all those, the full record just together and present it to the registrar of the High Court. So, and what are we asking? We are asking basically in terms of our prayer for that that amendment should be reviewed, set aside, declared as unconstitutional and invalid ab origin. Ab origin is a legal term used to say that it was invalid from its inception. And yes, people, these regulations that he promulgated on the 4th of May is automatically invalid. The reason for it is the fact that he was supposed to, in terms of Section 94A, give a 3-month period for consultation. And when you go to those very regulations that he published, and this is the Government Gazette of the 4th of May, he says here that the Minister of Health has, in terms of Section 91 J, K, and W of the National Health Act, made the regulations in the schedule. Now, people, those are not immediate or emergency regulations. Those are regulations, normal regulations. So if he did not follow the 3-month period, he was not able to promulgate it and make it effective from the 4th of May. And this is sadly something that I've warned before. Why did we as Liberty Fighters Network not challenge these draft regulations before they came into operation like other organizations did? And I repeat that there's no golden rule. There's no golden rule to say that they were wrong and we are right. Each one has got his own idea of fighting this, and we invite and celebrate each one of these attempts. So what they have done in the Western Cape is not necessarily wrong. In fact, they have now put the government in the position with our application to not know what to do, because they have now promulgated different ones than the draft ones. And so those were not challenged then, or these were not challenged in the Western Cape as such, because they were simply not available. It's slightly different than those that were proposed. So now we can come in and, based on our application, to review, to ask the court to review that decision, we can now say, okay, people, that the respondent, that this is the part, so the respondent is called upon to show cause why the applicable decisions relating to and giving effect to the amendment should not be reviewed, corrected, declared invalid, and or set aside. And then here's the nice part. Kindly note that the respondent is further called upon to, by Thursday the 12th of May 2022, dispatch to the registrar and upload to case lines the records of the mentioned decisions, including all internal memoranda, directives, policy documents, records, and transcripts of deliberations, minutes of meetings, and any other documents relating to the applicable decisions, together with such reasons as the respondent by law required or desired to give or make. And what makes this review process much better is that now, after we've received the records, if ever we're going to receive it, we as the applicants may then supplement our founding affidavit based on the record that the minister is going to produce. So then we've got the evidence that we can attack. And then we can supplement our founding affidavit based on those records or the lack thereof. And then the minister can answer to our answering affidavit or to our founding affidavit. And then we can also put in our replying affidavit by Thursday, just before Tuesday the 24th, so that all the necessary evidence is before the judge who's going to be assigned to this matter. So previously in other court cases, what we also did in the beginning with the National State of Disaster Challenge is that we did not follow the review process. We made claims and then they just simply said, but your claims that you have made is actually thumb sucking and it's not proven. And so you are wrong, we are right. Although they were supposed to produce the evidence to disprove that they were incorrect, they did not do that because they were legally not obliged as such to have done it because it was never a review application. So we are now saying that people, let me just quickly go through our application to highlight the most important points, and then you will see that the purpose of the application. Summary of race, constitutional, and other issues. So we are saying that even if the court might find that um, the regulations are lawful or the promulgation thereof was lawful and that the 3 month period was not necessary, we are also challenging in our application the constitutionality of it. And now that we've got the record or should have the record, that record should be similar to the one that the Minister of Cooperative Governance and Traditional Affairs, Dlamini Zuma, was supposed to have entered and utilized, which never appeared. Because of the fact that the very measures that these health amendments are trying to implement are basically the same as the ones, or no, not basically, essentially the same as the ones that were introduced in the Disaster Management Act regulations. So, people, um, we're going to challenge the constitutionality thereof in any event, which would include the vaccinations. A very interesting point that always pops up is that why do they want us to show proof of that we have been vaccinated in order to enter a so-called gathering or a test which is not less than 72 hours old? But the reality is that even if you have received the vaccination, you still can get COVID. So why are those who are vaccinated also not tested? And besides, in late December 2021, the health department has specifically discontinued the tests relating to COVID-19 to say that it's not necessary to test someone if you are not symptomatic. So if you are asymptomatic, you are under no obligation to be tested. And let me also just show you the interesting thing which the government has now done was that besides this, I would like to show you something. Um, there's a very interesting, here it is, the amendment to Annexure A to the regulations. Now, they have said that Table 2 of Annexure A to the regulations is amended by inserting the following item between existing items 5 and 6. 5A, corona disease, COVID-19. um, People, let me just go to the original or the applicable health regulations as those are applicable at present. When you go to table 2, there's a table 1 which is serious. All these in these regulations here in this table are serious. They need to acquire immediate reporting. And table 2 should be in 7 days. So meaning that when they have put coronavirus, the COVID-19 in table 2, it's not as serious as above others. Item 18 here, a respiratory disease caused by a novel respiratory pathogen, which were examples of novel respiratory pathogens include novel influenza A and MERS coronavirus. There you've got it. The government has essentially confirmed that COVID-19 is less a notifiable disease than the flu. um, People, I'm totally flabbergasted each and every time when I see what the government is doing to shove COVID-19 down our throats. Um, and sadly, yes, people have died because of so-called COVID-19 or they believe they did. Um, and government also wants, with these coming regulations, to say that all evidence must be destroyed relating to COVID-19, um, which were measures in terms of the Disaster Management Act regulations. So, people, I'm going to keep you posted. I'm not going to go into further detail. I'm going to update you regularly on the progress of our court case, and whether we're going to be successful or not. If we are not successful, we're just merely going to confirm that, number one, the judiciary has been captured. Secondly, government doesn't want to cooperate. They can't cooperate because the whole COVID-19 issue could be controversial. Thank you very much for supporting us. Please remember, we've our membership have been updated and sorted out with Google AdSense, so you can now join again as a member. We've in fact made an option, one of our memberships, less cheaper than the one that we had originally. And prescribe otherwise. Like this video, share it as far as possible, and ring the bell in case you'd like to receive further notifications of what we are doing. Thank you very much and have a blessed day. God bless all.